Good morning. While they are getting situated, I'll go ahead and start with the introductions. I'm Bridget O'Brien, Deputy Court Administrator at the 8th District Court of Appeals, and it's my pleasure to introduce our first segment addressing the record on appeal. With this segment, we hope to not only impart best practices and increase your knowledge, but most importantly, to make these key introductions so that in the future, you know who to call to ask questions. Okay, so we have both esteemed representatives from our local clerk's offices, as well as talented attorneys from the 8th District Court of Appeals. First, from the clerk's offices, we have Gregory Hersick, Supervisor, Court of Appeals from the Office of Nyala K. Bird, Cuyahoga County Clerk of Courts. Janine Nickerson, Director of the Clerk of Court, Cuyahoga County Juvenile Court, and Saranya Green, Criminal Division Senior Clerk from the Office of Earl Turner, Cleveland Clerk of Courts. For their detailed biographies, I ask that you look to the program, which on the QR code on the back of the program, you can pull up all of their personal biographies. Additionally, from the Court of Appeals, we have two staff attorneys, David Parcham and Jake Dykes, and Judicial Attorney Tony Farkas. Due to time, I ask that you hold all your questions to the end. We have reserved some time for a question and answer period. And without further delay, I will turn it over to Dave to begin. Thank you.
Good morning. I'm David Parcham, and I have been a staff attorney with the 8th District Court of Appeals for over 33 years now. I'm here to give you a very quick and dirty introduction into the record. I often tell people the purpose of the Court of Appeals is to determine whether or not the trial court made a mistake based on what was before the trial court. The corollary to that is you are limited to the record as it was in the trial court. As a second corollary, we do not take any new evidence. If it wasn't before the trial court, you can't use it, you can't introduce it to us. Because of that principle, what was before the trial court? As an example of this, when I was practicing, I got into a case at the appellate level. And in this case, there was a critical deposition. It was taken, everybody knew it was out there, everybody used it. We even attached a couple of pages, both sides attached a couple of pages to their dispositive motions. But nobody actually filed a deposition in the trial court. Consequently, when I got to it and I'm seeing potential holes, I can't correct those. I can't say, hey, please take this deposition. Everybody knew it was there. That wasn't going to work. What we were limited to was just those pages that we had attached to our dispositive motions. That's the only thing we could use. So the takeaway, first of all, is if you needed something in the record before the trial court in order to pursue your appeal, you must have it in the record. You must make sure it's filed before you take the appeal. And finally, as a courtesy, the judges of the 8th District Court of Appeals have made their staff attorneys, such as myself, available to answer questions on appellate procedure, including the record. So if you have a question on how do I try to, when's the record due? What can I do to try to fix it? What's the form that I have to fill out to get something ready? How do I refer to the record? Questions like that. Call the 8th District Court of Appeals at 216-443-6350 and ask for the staff attorney on duty. I would mention that in this past week alone, I have had at least 2 calls about the record. Thank you.
Good morning, everyone. My name is Greg Hersick. I'm the supervisor for the Court of Appeals in the Clerk of Court's office, and we're going to navigate the appellate process. So this presentation, we're going to cover some commonly made mistakes by attorneys during the appellate process. And during the process, we see three major areas of concern. Those three are e-filing, and during the e-filing process, we often see that attorneys fail to file their notice of appeal in the trial court docket. And when this occurs, it slows down your process. We also see issues in exhibits and transcripts. Attorneys should always check with the clerk's office regarding the status of their transcripts and exhibits pertaining to a case. And finally, in juvenile cases, all of your filings in juvenile cases need to be redacted. You can use initials or generic terms such as mother, father, and child. The first section we're going to cover is the e-filing section. I'm just going to give a couple quick overviews, then we're going to go into like a detailed view of how we go through the entire process. But your appeal must first be filed on the trial court docket. When you follow the steps I'm going to show you correctly, it will take you from the trial court section of the e-filing queue into the appeals section of the e-filing queue. And if you do not follow these steps, there will be a delay. We've seen attorneys will file on the trial court docket, and it brought to our attention maybe 3 weeks later. They finally kind of recognize, hey, I haven't been given an appeals number, and we just see it's just hung up in the system. And it's not possible for us to see it unless you go through all the steps. So this is gonna be filing on your underlying case. So some of the big topics I want to discuss are the docket type will always be notice, your docket detail will be notice of appeal, and your full document title will be notice of appeal. And then you will choose your filing party below. After you file that, this is where you'll be attaching your documents. Now, most attorneys will just file their notice of appeal on the trial court docket, which is mandatory. You cannot proceed unless you file your notice of appeal. It's acceptable to file your notice of appeal and your precedent document statement as one document on the trial court docket or separate on the trial court docket, but it's mandatory that you do file at least your notice of appeal on the trial court docket, and they must be in PDF form. And another thing I just want to bring to your attention, as you'll see on these slides, there's always that red lettering at the top. Just kind of recognize that. That's kind of like, hey, don't go past this point unless I've done this step. And then this is the final screen, which you will see on the trial court docket. It's just going to be a quick overview. It'll just show the trial court case, the case caption, what kind of case it is. In this example, it's a criminal. And then it'll go through the subsequent screens. Your filing review will be that first slide that I showed you where you selected your document type and the parties. And then your document review will just show you what documents that you have in fact attached. So once you go through that screen, you're going to transition. There won't be any big flashing lights like, hey, you're going to be in the appellant section, but just know that once you see that screen, you're now going to be in the appellant section. And the appellant section, they look the same. There's a little more that you're going to have to add in here. Some of the big topics I do want to discuss are, if you see in the new case filing sections, the radio button that says notice of appeal, that should be selected. Your case type, it's kind of self-explanatory. Please fill out the case caption again, the plaintiff and defendant title, the trial court case number, and always make sure to attach your final judgment. We often see that too, where an appeal will be filed with no order attached, which is kind of important because that's what you're appealing. And then if there's an poverty affidavit attached, please attach that. And then finally, which we're going to be discussing in the subsequent slides, the record type 9A, meaning that you just want the trial court record, 9B, you want the trial court record, and the transcripts and exhibits. And again, you'll be asked to add parties, the appealing side, the appellant, and the appellee. Finally, this screen is where you will add your precedent document statement if you haven't filed it initially. You can also refile your notice of appeal if you'd like. I mean, it never hurts to have it on old dockets. So your screen should look like this at the very bottom. Where you see the arrow, where you should have your notice of appeal and your precedent document statement. So now, since I brought that up earlier about the 9-day record and the 9B record, the 9-day record again indicates that we are just expecting the trial court record, which is the clerk's responsibility to prepare. By selecting 9B, that indicates to the court that transcripts and exhibits will be filed along with the trial court record. Now, once a 9B record is submitted, it is the appellant's responsibility to serve the court reporter that there will be transcripts and exhibits needed. The court reporter holds all those. Another big thing we are seeing is you guys can call into our office, which I'll give you the number later, or check on the e-file screen. Your record due date is the most important date. That is the date when the trial court record and the transcripts and exhibits are due. This due date will shoot off all your other important dates, your appellee brief, your appellate's brief, the reply brief. Everything will stem from this, so please, kind of keep that in mind. And again, you should contact the court reporter in the clerk's office. Our number is 216-443-7937. So once you recognize that due date, call about a week before. I will say the clerk's office, we usually have the record weeks in advance, but it's always coming down to, it seems like, transcripts and exhibits. So at least it'll be nice to have a week in advance so we can look for those things. And once they are filed, please come in and check them, just to make sure everything's there. That's one of the big things we see. Just one thing missing, that could be the most important thing in the case. So just please come in once they're filed to see if everything is there. And then finally, on juvenile appeals, any filing, please redact the names. Not redacting it will cause you to have to file an amended notice of appeal, which will cause a delay. And the juvenile court reporters are Mizrani reporting services, so they are separate from common pleas court reporters who cover civil and criminal, and then domestic relations also has their own court reporters. So just kind of keep in mind too, if you're dealing with different cases, you have to deal with different court reporters. Thank you, everybody.
All right, so for about the next 15 minutes or so, I'm going to talk about filing your appeal when you're appealing a decision from the juvenile court. So allow me to give you a little quick dive into the bit of juvenile law. I find that attorneys either love it or they hate it. And some are intrigued, but maybe a little bit intimidated. So I would offer to you that it is a wonderful practice, and if you have any interest in juvenile law, we certainly encourage you to get on the assigned counsel list for the juvenile court. And it's a great way to supplement your practice, as well as do some really good work. And then, in addition, of course, if you're on, or if you haven't gone on, please get on the appellate court's assigned counsel. They are always looking for attorneys who practice in juvenile law, but also do appellate work. So you can find yourself to be quite valuable if you choose to do both fields. So the juvenile court jurisdiction is under 2151, that too, the revised code. I was really proud of my slides, and then I was reading through it again, and I realized I left off a whole bunch of stuff that we do, but understand that we primarily do the private custody support and parentage actions with regards to children of unwed parents, abuse, neglect, dependency. We do some miscellaneous things like the abortion consent, marriage consent. We also do interstate compact cases and a lot of other things. If your appeal deals with those subject matter, those different subjects, obviously, then the trial court that you're dealing with is our court, the juvenile court. In terms of filing your appeal with the juvenile court, the notice of appeal, as Greg said, it is important to protect the children and the identities of families that are the subject of these proceedings, and it's a requirement of the appellate court's local rule that you have the juvenile names and associated members' names redacted. Typically, as you said, people do the initials. For us, in terms of filing the notice of appeal and document statement and precipice, you can file that either in person or you can file it to our dedicated email inbox. So we accept email filing, which is included on your slide, the dedicated email address that you need to send it to. Included in your packet also is a little bit of further information with regards to our online payment system as well as email filing, and then our local rule 22, which applies to email filing. But as it relates to the notice of appeal, just understand that for purposes of the timestamp, whether it's in person or it's by email, your appeal will be timestamped the date and time in which you receive it, whether again it's by in person or by email, regardless of whether or not you've made the payment right away. Of course, the payment is required, and we'll be following up with that, or the Court of Appeals will do, but that will not prevent you or your client from being able to file, obviously, because the date and time are very sensitive and jurisdictional, so we don't want to mess with that. Understand with us, there are two separate payments that need to be filed. So one is the $175 to the Court of Appeals. There is also a $40 charge for the trial court, so payable to the juvenile court. In terms of our online payment system, you can do the $40 through our online payment system. You cannot do the $175 at this point for the Court of Appeals payment. So that would either have to be by mail or in person to the juvenile court. And yes, of course, there are instances where you would be representing indigent clients. Even if your client is found indigent by the trial court, we ask that you still fill out the poverty affidavit, which is part of the materials for the Court of Appeals when filing your notice of appeal as well. So recording a juvenile court proceedings. What must the juvenile court actually record? And actually reviewing the law that applies, I was fascinated, but revised code section 2151.35 as well as juvenile rule 37A apply as to, and tell us what we are required to record. And that includes adjudicatory dispositional hearings and abuse neglect dependency cases, as well as delinquency or unruly cases. We are also required to do any oral proceedings and testimony with regard to permanent custody cases. Any proceedings before a magistrate must be recorded. But interestingly enough, missing from that statute in the local rule, or excuse me, the juvenile rule is the following. If a matter is heard by a judge, not the magistrate, but a judge, pre-trials, support matters, traffic matters, private custody matters, bypasses, and marriage consents are technically not required to be recorded by the trial court. Notwithstanding, it is our common practice to make sure that we record all pertinent hearings in general hearing. But if you are in doubt, just make sure that you ask, and like he said, perfect your record. So what happens if the hearing is inadvertently not recorded? So in the history of our recording system, it's not ever gone down, and we have backups and redundancies for that. But certainly there's human error in terms of our clerks perhaps not pressing the record button on our court smart system. So what can we do? If the matter is heard by a judge, as you know, the appellate rule provides the ability to file a 9C statement. However, if the matter is heard by a judge or a 9C is not possible, you are stuck with the matter being remanded by the Court of Appeal back to the juvenile court for rehearing. And so I've cited to a couple, courtesy of my law department, to a couple of those cases that outline that very instance or situation. All right, so use of court recorders. Again, we use an electronic audio device to record everything. We have it set up in each individual courtroom, and that is permissible under our local rule as well as the juvenile rules. And we use a contracted court recorder to transcribe any proceedings that you need transcribed. We do use Mazanin court recording, and I put their information in there because that is very important for you to have in terms of the contact and to follow up with, in addition to the juvenile clerk as well. So Kendall DeWitt is the liaison for Mazanin, who is the person that the court deals with, but also your primary point of contact if you are requesting transcription services and your client is paying. Just want to also point out that local rule 34C, our local rule, do allow for, or does allow, excuse me, for parties in permanent custody and mind over cases to bring in their own court recorder, but you must do a motion before the court and it must be approved. I'm not every single one denied, but it is required by our local rule to have the consent of the assigned judge. On the next slide, it just gives, excuse me, a little bit of an example here of our current contracted pricing per page through Mazanin. Obviously, the shorter time frame you need, the more expensive it gets per page. And so that turnaround, of course, is based upon the date that you supply the clerk's office with a transcript audio request form, which I'll get to in the next slide, and of course, your record due date. So the quicker that you're able to submit that form and any necessary orders, if you are getting an order for the transcript at the state's expense, the better off it is for everybody, less pressure on you and the clerk's office, and also, of course, more cost effective. So some general information with regards to requesting the transcript. Again, so juvenile rules say that you cannot make a public use of any kind of juvenile court proceeding without either an appeal being filed or without a court order, or unless there's some statute that applies as well. Since we're talking about appeals here, that initial pump there, you already have jumped over because you filed the notice of appeal. So you would be entitled to that transcript without any further order of the court, unless you are seeking a copy at the state's expense. However, the juvenile local rule 34 requires the filing of a transcript audio request form. I have included a copy of that form in your materials as well, so that you see what we're asking for. But just understand that that form, not any journal entry granting the transcript at the state's expense, is the thing that triggers my clerk to start to prepare your transcript for you. Oftentimes, and if you look at the journal entry that the judge would give you if you did ask for a transcript at the state's expense, it does direct you to contact the clerk's office for further instructions. However, as we know, a lot of times people don't need their journal entries, and then I get a call a month later asking where my transcript is, and then I have to look and explain, you need to submit this additional form. We generate tens of thousands of journal entries every month. And so on occasion, although we do send, my journalization department sends the journal entries with regards to transcripts to my appeals clerk, there are just times that we miss it. So again, it always helps that attorneys are able to and willing to follow up to make sure that the record is being prepared in a timely fashion for you. And I will also include our contact information so that you can harass me if you need anything. Actually, it's not harassment. I love the calls. I miss the attorneys. You know, I'm ready to call out at the back of my office now. So I love it when you call. And I like to hear the feedback, positive or negative, in terms of how we're doing. On the form, if you check appeal, we will give you all of the hearings that are pertinent to your appeal. So generally, obviously, if it's an initial case, anything from the date of the filing the complaint on. If it's a post-dispositional motion, then of course you would generally go unless you ask otherwise from the date of that dispositional motion or the prior journal entry, and then what triggered it on forward. I've also included a copy of the local rule in your materials in case you want to read it as well, but that's the gist of it. All right, so here are the steps in terms of requesting your appeal. I added a copy of that flow chart, don't worry, in your materials, but I also put it on your side as a cruel joke to see how many people would split. Unfortunately, even the version that I put in your materials is kind of small. But you'll get the point. So in terms of filing with us to get the transcript, of course, both whether the client is paying or it's at the state's expense, you start with the notice of appeal that is filed. Then thereafter, if your client is actually paying for the transcript, just look to the left of the chart. If your client is indigent, then you would go to the right of the chart. But when a client is paying, you want to make sure that you again file that form, the audio request form with the juvenile clerk. You would then be responsible for contacting the Xanon directly, and I have their phone number again in the materials to get an estimated cost of the transcript. They would then contact us. We would provide the number of hearings and length of hearings, which gives them again the estimated cost based on your record due date. Once you have made payment to them in advance for the preparation of that transcript, they would then contact the juvenile court clerk so that we can again begin to compare everything that's necessary for them to be able to transcribe. If your client is indigent, of course, the initial step would be that you would be filing a motion to transcript at the state's expense. And then, of course, contact the clerk's office here, us instead of the Xanon, to make sure that we are preparing it in a timely fashion for you. And then we'll take care of the payment details. All right. So preparing the appellate record, you'll probably hear a little bit about this again in terms of later on in the panel, but the public case file versus the appellate case file, and I'll go into that a little bit more in the next slide. But just understand that these are the materials that the juvenile court sends down. Something probably more unique to the juvenile court, although it could happen in any case, is that we do have confidential records that we put in a separate file that would be submitted to the Court of Appeals that you would not see in the public trial court case file, but it is something that the appellate court would need in terms of reviewing our decision. So what are these confidential documents? Here's a list of our most common ones. The first two involve, so generally, of course, we can't just single-handedly say something's confidential. It needs to be backed up by a statute or a rule. So those are the things that we would, again, by statute or order of court of rule, set aside and put in a confidential envelope for the Court of Appeals. The first two involve just protecting private addresses of public officials if requested, and or if someone has requested a private address under the UCCJEA on a custody matter. We have CFS records, which we don't disperse to parties. Of course, we would refer them to CFS if they wanted copies of those, but again, they go with the Court of Appeals in that separate envelope. GAL reports, social history reports, and probation reports, and delinquency matters, and then the diagnostic clinic evaluation, which could be on the custody side as well as the delinquency matters. Any documents within a case that may have been stricken, excluded, or otherwise by the trial court, that the trial court has had such that the appellate court can review those decisions and those rulings, and then in-camera interview transcripts we again don't release to parties. We submit that directly to the Court of Appeals. All right, we're almost done, but wait, there's more. Links to some of the information in terms of our website, local rules and things if you do choose to supplant your practice with juvenile law practice, and or if you're doing appeal from one of our decisions. And then here's the goods, the contact information. So if you need anything, please feel free to contact me or any one of my staff members. I've listed the pertinent individuals who deal with our appeals. We are always happy to help. And I know as part of this in this panel, we just want you to know there's a collaboration, that we're here to help assist you. Of course, there's things that we need from you, but we want to assist you in making sure your record is getting to the Court of Appeals in a timely and hopefully seamless fashion. Thank you.
Hello, my name is Serena Green, and I am a supervisor in the Earl B. Turner Clerk of Court's Office Criminal Division. I handle the appeals for all general division cases and housing cases if it's a criminal matter. I would like to give you a few best practices on filing your transcripts when you are filing an appeal. As Greg and Janine discussed before me, that you need to have a transcript, and here are a few best practices. They are: you will have to reach out to the court reporter's office on the 10th floor of the Justice Center via phone or the link that is supplied with you today. And the link is also on our website. This applies only to the general division cases. But then pay the court reporter's office their fees, and then they will prepare your transcript and exhibits and bring it to the clerk's office for filing. I will make sure that your transcript is submitted to the Court of Appeals on your behalf. If you are appealing a housing case, either civil or criminal, you will reach out to eScribe via email or phone, or you may contact Roosevelt Coast III and he will assist you. Please make sure that when you pick up your transcript from eScribe, that your transcript is bound in a clear and a vacuum. This is an example of what a transcript looks like. Because you have to make sure that when it's like this, that the Court of Appeals does not misplace it or treat it like as an emotion. And then make sure that your exhibits are inside of your transcript when you bring it to the 3rd floor of the clerk's office, general division, or the 2nd floor if it's a civil housing case or civil cases. And then we will timestamp it and make sure that your transcript is submitted to Court of Appeals in a timely fashion. These are very important things that you need to look for, because sometimes they call me and say, we're missing a transcript. And I say, no, it's been signed for by XYZ. So it's very important that when you apply for your transcripts via court reporter's office or e-scribe, that you make sure that it's bonded in a clear and a backing, so it would not be misplaced. Lastly, once a decision has been rendered from Court of Appeals, the file will not be returned to the lower court until 45 days or longer, due to the appellant or appellees wants to file an appeal to the Ohio Supreme Court. If you have any questions, you may reach out to myself via phone or email for the General Division, or to Judy O'Leary for any civil cases via phone or email. Thank you.
All right, I'm going to talk a little bit about the recipe. The court has recently redesigned, expanded its form section on the website. So if you're still using the same recipe you downloaded 10 years ago when you started appellate practice, please go to our website, download the new recipe. It has been updated for things like Marcy's Law interlocutory appeals and other things. We have also worked with the General Division and the court reporters to make it pretty straightforward to order transcripts from their courts. So you see that little note there. That note says you just need to email your recipe to this address. If you already have an order granting a transcript at state's expense, you can attach that along with it. Otherwise, contact them for payment information. We also have on our website an appellate brief template for Word. So if you're just starting or want to get into appellate practice, we've done a little bit of the work for you to make it a little easier. So we're going to talk about a little bit about your options in the recipe. So Appellate Rule 9C, it's pretty straightforward. It's required to jump through a few hoops. The appellant supplies the statement of the evidence to the other side in the trial court. The other side gets an opportunity to object, and the trial court resolved all of those issues. But I want to talk more, focus on Appellate Rule 9D. Some courts have gotten a little lax in the language. You'll see cases that say, well, appellate, you didn't provide us with a transcript, or you use Appellate Rule 9C or 9D in lieu of a transcript. But Appellate Rule 9D is in lieu of the record, not a transcript. So an example may be in the midst of complex litigation, you have a claim that an insurance company has a duty to defend an insured. And the trial court makes a determination one way or the other, and an appeal is filed. Those parties can get together and say, hey, look, the appellate court doesn't need this voluminous record. They just need the insurance contract, maybe the complaint, and they can decide this issue on a thin record instead of sending 6 boxes of evidence over. So we'll get together, we'll do that. So this is very rarely used, and situations are fairly rare. But getting back to Appellate Rule 9, Appellate Rule 9B for a transcript. The rule requires that a trial court, that the record establishes that the trial court has appointed a court reporter for those that don't have one under contract. And our local rule tries to make that more clear. You see a lot of cases where sometimes the trial court doesn't recognize the fact that that needs to occur on the record where it's clear that the court reporter has been appointed. So for the General Division and the Cleveland Municipal Court and the other divisions of the Common Pleas Court, the process for requesting that transcript and getting it is fairly easy because they're under contract. That court reporter is under contract. It's fairly easy. They're listed on their websites, the procedures to do that. But a lot of the municipal court, other municipal courts in Cuyahoga County, it's a bit of a mixed bag. So the Lyndhurst Municipal Court, I just did a quick survey of local court rules. They do not have a local court rule regarding the recording of hearings or how to request a transcript. That leaves the parties in a position where they don't exactly know what to do. Berea Municipal Court has this, they have a rule that's similar to a lot of other local municipal court rules, but theirs seems to indicate that the trial judge or the court doesn't really have any responsibility in terms of getting the transcripts, which may be in conflict with our local rule, which says the trial court must appoint the court reporter if one isn't under contract. So several other municipal courts have similar rules that don't exactly provide you with what you need to know to do. So you can file a motion with them asking to appoint a court reporter for that. But then you have the Rocky River Municipal Court. This is a great rule. It is very clear. It does allow you, it doesn't require you to jump through some hoops, like providing an unopened thumb drive, where a lot of the other courts will provide you with just a DVD or CD. But it has everything you need. Anyone practicing this court knows they file a motion with the trial judge or the magistrate. It was before magistrate. It has everything you need. It directs you as timelines for the court, for the parties, for the court reporter. It's pretty great. So what do you do if you're having trouble getting a transcript in a municipal court? First thing you do, you file a motion with the trial court asking to appoint a court reporter. Make it easy on the trial court. Name a court reporter or a qualified court reporter agency or court reporter to do that transcribing. If the judge doesn't rule the motion, sometimes the judge thinks they don't have jurisdiction because there's an appeal pending. File a motion with our court asking us to direct the trial court to rule in this motion to appoint a court reporter. If any of that doesn't work, still are in the bind, give us a call, like Dave said, and we can try to assist you with contacting or get that done.
Morning, I'm Tony Perkins, and I'm going to be continuing the discussion about best practices and avoiding pitfalls with regard to the record. I'm only moving to the podium because I tend to move when I talk, and it's probably best for all involved if I talk at the podium as opposed to up with my colleagues. But it's not because I don't like sitting with my colleagues. To put that in perspective, and I might be aging myself a little bit with my images here. So, but that being said, I'm going to focus on best practices and avoiding pitfalls when creating the record and using it to support your appeal. As a starting point, it's important to remember what constitutes the record on appeal. It's defined in Appellate Rule 9A as the original papers that are filed with the trial court, the transcript and exhibits, and the certified copy of the docket and journal entries. I would say the use of the appellate record is creation and use of the appellate record is sort of centered around four basic principles. And Dave talked a little bit about this, so I'm sort of reiterating some of these important facts. One, the record is the foundation of the appellate court's decision on appeal. Two, an appeal begins and ends with what's in the record. For purposes of appellate review, any parts of the trial court record that are not included in the record on appeal don't exist and will not be examined or considered by the appellate court. Three is what I call the show me the money principle. As an appellant, you need to show the appellate court exactly how and where a prejudicial error was made as reflected in the record. And four, certain errors and omissions in the record can be fixed if done timely and others cannot. If you've ever wondered what an appellate record looks like when the appeal is ready for review by the panel of the 8th District, I thought I'd sort of give you a little behind the scenes view there. Documents that are filed under seal are maintained separately. And in appeals from the Common Pleas Court, panels also have access to electronic versions of most documents that are part of the record. When talking about the record, it's important to recognize that there's a difference between the appellate record and the trial court file. What's in the appellate record in a particular case depends on the ruling or judgment that's being appealed and what was presented to the trial court below related to that ruling or judgment. Not everything that may make its way into the trial court file that's transmitted to the Court of Appeals may be a part of the appellate record for your case. Different rulings in the same case may have different appellate records. For example, a record in a direct appeal versus a record in an appeal of a denial for a post-conviction relief petition, the record in a ruling with regard to summary judgment versus the record in an appeal of a ruling of a motion for relief from judgment. Also, if something was not before the trial court when making a particular decision, the appellate court likely will not be able to consider it on appeal, even if it's in that trial court file. Sorry, these are small, I apologize. But these materials are all, or these are also in your materials, so if you have trouble seeing them, but just some additional concepts to keep in mind with regard to the record. A document could be properly considered part of the record, even though it was not actually considered by the trial court in making the decision being appealed, if the trial court had the opportunity to consider it and declined that opportunity. For example, an exhibit that was denied admission, something that ends up being struck by the docket. And in fact, those might be the basis for some of your assignments of error on appeal. Turning back to that first slide I had, record materials have to be the type of materials that are identified in Appellate Rule 9A. And if something is not in the trial court file, that does not necessarily mean it should be not part of the appellate record. If the trial court reviewed or relied upon material when rendering a decision that was inadvertently omitted from the record, an argument could be made that it should be part of that appellate record with steps taken to supplement the record in accordance with Appellate Rule 9E, which I'll talk about in a little more detail later. And Janine mentioned this in her presentation, but there's parts of the materials that are not part of the public trial court file, but that are in fact part of the record. For example, documents filed under seal or other confidential documents. When we're talking about best practices in creating and using the appellate record, what we're really talking about is ensuring that that appellate record is complete. I'm sure you've heard it said that it's the appellant's duty to ensure the completeness of the record on appeal. Well, what does that really mean? There are two components to this duty. One is making sure that that complete physical record gets to the appellate court. And that's a shared responsibility between the appellant and our court clerks. And then there's also making sure that any trial court error and resulting prejudice is properly captured in the record and preserved for appellate review. And that's going to be the appellant's duty alone. With regard to the first aspect of an appellant's duty, that's described in Appellate Rule 10A. The appellant shall comply with the provisions of Appellate Rule 9B, that's relating to the transcript, and shall take any other action reasonably necessary to enable the clerk to assemble and transmit the record. The staff notes to Appellate Rule 10A sort of expands on that a little bit. It sort of recognizes that the appellant does not have the ability and does not have the duty to ensure that the record is transmitted once those reasonable arrangements have been made. The appellant should not be penalized for any failure in transmitting the record if the deficiency is outside the appellant's control. Local rules may also address an appellant's duty with regard to the record. And I've cited our 8th District local rule here. It's very consistent. It talks about the duty of the appellant to cooperate with the clerk of the trial court to secure transmission of the record. There also may be some specialized rules. For example, we have a special rule with regard to the record in asbestos cases. I'm not going to talk about that in any detail, but you definitely want to look at those local rules and see if you have any additional obligations you need to comply with. As you can see in the appellate rules, and you'll also see this in some cases, there's a recognition that an appellate doesn't really have the ability to supervise the court clerk and compel the proper transmission of the physical record. But there's also a recognition in a lot of the cases that some deficiencies in the physical record may be in whole or in part attributable to matters within the appellant's control. And therefore, part of his or her duty to ensure the record is complete. For example, missing exhibits that were never given to the court reporter. You'll see our clerks are amazing. They work really hard to make sure that a complete record is transmitted to the Court of Appeals, but they can only transmit what they have. And they may not know that there are some additional materials that are properly part of the appellate record that should go to the Court of Appeals. Cases also recognize that there are mechanisms available to an appellant to recreate or correct deficiencies in the physical record under Appellate Rule 9. And they recognize that an appellant may have a duty to actually employ those mechanisms to ensure the completeness of the record. Bottom line, as an appellant, you don't want to be in the position of trying to argue that a deficiency in the physical record wasn't your fault and was outside of your control. And in any event, if the record doesn't have the information that you need to support your appeal in your assignments of error, the appellate court might have no choice but to affirm. It's not a situation you want to be in. I would be remiss if I didn't point out that there are some very rare circumstances in which an incomplete appellate record may be grounds for reversal. Usually you see this in cases, for example, criminal cases or juvenile court cases where there's some statutory duty to have a recording of proceedings and something happened and that recording was not created. And there's no means by which they can sort of recreate an alternative record. So it's not an exception I would rely upon. So how do you ensure that the physical record is complete? Review the appellate record. Greg talked about this. Once the record has been transmitted to the appellate court, or as Greg suggested, even before it gets transmitted to the appellate court, review the record to make sure that everything that should be in there or that you need to support your assignments of error is in there. What should you be looking for? Everything that you need to support your assignments of error. Exhibits and key documents, are they complete? Are all relevant transcripts present? If you had some kind of documents that under seal or that were submitted for in-camera review, just confirm that they've been transmitted as part of the record on appeal. With regard to timing, don't wait to review the record until you receive notice of oral argument if you can avoid it. By then, briefs have already been filed, and the panel may be actively reviewing the briefs and the record. And I would also suggest calling in advance. It avoids delay if the record's been checked out. You saw where we have our records there, it gets checked out by staff attorneys or one of the judges. And so we may need to make sure we can, get it to you in a timely fashion. And also once it's checked out, sometimes we put post-it notes on it. We're going to have to remove those before you get to look at the record. So what if something's misstated in or missing from the physical appellate record? What do? Appellate Rule 9E provides a means to fix it. Under Appellate Rule 9E, if any difference arises as to whether the record truly discloses what occurred in the trial court, the difference shall be submitted to and settled by the trial court and the record made to conform to the truth. If anything material to either party is omitted from the record by error or accident, or is misstated, the parties by stipulation, the trial court, or the Court of Appeals can direct that the omission or misstatement be corrected, and if necessary, that a supplemental record be certified, filed, and closed. Let's break that down a little bit. That's a lot in that rule. There's basically 4 ways that you can correct or supplement the appellate record under Appellate Rule 9E. The parties by stipulation can do it. Usually that's by filing a joint motion to supplement or correct the record. It's important to note, though, even if the parties agree, it has to be shown that if you're trying to supplement the record, that any material sought to be added was in fact before the trial court. You can't agree to add something that wasn't before the trial court as part of the record on appeal. With regard to the trial court, only the trial court can resolve disputes as to whether the record truly discloses what occurred. So if the parties don't agree, you're going to have the trial court resolve that dispute. And it must involve matters that occurred in the presence of the trial court. For example, if there's something that happened below, the parties had some issue or talked about something that wasn't before the trial court's not going to be able to address that and supplement the record. The Court of Appeals, on the request of a party, for example, by a motion to correct or supplement the record, can take action to correct or supplement the record. A party has an obligation to take prompt action to correct the record upon discovery of an error or omission in the record or risk forfeiting that. And again, it must be shown that any material sought to be added was in fact before the trial court. And the Court of Appeals sua sponte may take action to correct or supplement the record, usually supplementing the record in this case. If an issue is not raised with the parties, different panels may take different approaches to missing items in the record. Depending on what's missing, the panel may just ask our own court staff to try and track it down. This usually happens if, for example, we notice that all the exhibits are missing for some reason. So our court staff may contact the court reporter to see if they have them, contact the trial court clerk to make sure that they aren't there, or sometimes even contact the trial judge to make sure that something wasn't left behind there. The panel may also raise an issue with the record, relating to the record with the parties at oral argument. So that's one reason why waiting oral argument might be a bad idea. You might not know that there's an issue with the record and the panel might raise it with you there. The panel might issue an order directing that the parties supplement the record. And quite frankly, if it's something material and it's noticed that something's missing from the record that should have been in there, that happens with some frequency. The court will just direct the parties, hey, we're missing joint exhibit A, please supplement the record with joint exhibit A. Or the court in its discretion might just proceed with appeal without the missing material. The standard of review here, the standard of review with regard to correcting or supplementing the record is generally abuse of discretion. Factors that sort of come into play here are the type of case, is it a juvenile or criminal case, or a civil case? Whether the omission or error was within the control or fault of a party, when and how it was discovered, was it something that was discovered, right away, or as after oral argument's been held, how the material or how material the item is to the issues that are on appeal. There are some cases that say that failure to correct the record or failure to correct or supplement the record under Appellate 9E could be an abuse of discretion if the court fails to attempt to correct a known material error or omission that was not known to or the fault of the party, or if a material item was clearly before the trial court below and was inadvertently omitted from the record. Again, usually those are going to be, you're going to see those things in criminal or juvenile cases, or if something was just obviously, it was the whole centerpiece of what the issue was below, and for some reason it just got omitted from the record. Yeah, that's a good point. Yeah. Yeah, Judge Boyle's just mentioning the fact that we see this with in-camera reviews sometimes that those materials do not make their way over to the appellate court. And that's not something that our clerks would know even happened, because usually when you do an in-camera review, the materials are submitted directly to the trial judge, and they usually stay there unless they're retrieved. So what's not a proper way to supplement the record? Attaching materials that are not in the record to your appellate brief. We do see this with some frequency where things are just attached to appellate briefs. Supplementation under Appellate Rule 9E is not an opportunity to add documents or information that was not before the trial court. 9E permits the parties to correct or complete the record to reflect what actually occurred in the trial court. It's not a means to alter what actually occurred or did not occur in the trial court. Another means just sending a letter to the appellate court and say, here's some material that should be part of the record. That's not a proper means to supplement the record. You need to file a motion if you're going to do that. The consequences, if something material is omitted from the appellate record and not properly supplemented, again, for purposes of appellate review, any parts of the trial court record that are not included in the record on appeal do not exist and will not be examined or considered. And then there's the presumption of regularity. So what does that mean? What's the presumption of regularity? Basically, it means that the appellate court presumes that the trial court did what it was supposed to do procedurally with regard to whatever is missing from the record. And the appellate court will also presume that the trial court considered all the evidence and arguments raised. The appellate court will accept the factual findings of the trial court and will only consider some arguments with regard to issues of law or legal conclusions that were reached by the trial court. All right, the amount of material we've had is a little, some of this is a little dry sometimes, so I thought we'd try a little quiz here. It's not really a quiz, it's more of an application of some of these concepts, but here you go. Example 1, the facts here are email communications were exchanged between counsel and the trial court in connection with a motion to enforce the settlement agreement. So we're talking about emails between counsel and the trial court. Are the emails part of the appellate record? If the emails were not included in the trial court file that was forwarded to the appellate court, could the appellant use Appellate Rule 9E to supplement the record to include the emails? All right.
Nobody wants
This example is based on one of our cases. I have the site below, Pollock versus True Star Funding. And I should say, a lot of us, we may not have mentioned this, but a lot of us did provide some additional materials that you can, written materials that you can get for more information about some of these topics. And so some of these citations you'll see are in the record. But anyway, getting back to this case and this example. So are the emails part of the appellate record? No, it's according to the case here. If emails between the trial court and counsel were not part of the appellate record because they did not fall within the 3 categories of matters comprising the appellate record under Appellate Rule 9A, those original papers, the transcript of proceedings and exhibits, and the certified docket entries. The court held that emails to the court are not proper forms for litigating the merits of substantive issues and cannot be substitutes for proper motion practice. So could the appellant use appellate rule 9A to supplement the record to include the emails? No. Appellate rule 9A is a means of supplementing the record to include things that should have been in the record, but due to error or accident were omitted from the record, and the emails did not meet the requirements of that rule. If I change the facts a little bit, what if the emails had been attached to a motion to enforce the settlement agreement as an exhibit? Then I think you'd likely have a different result, because then they are part of the original papers that were filed with the trial court, and then fall within the scope of appellate rule 9A. And in fact, in that case, the trial court did point out there were some they were emails between counsel that were attached as exhibit to a motion to enforce the settlement agreement, and those were indeed part of the record. All right, so I said that there were sort of two aspects of an appellant's duty. I'm going to shift gears a little bit and turn to the second part of the appellant's duty, ensuring that the trial court error and resulting prejudice is captured in the record and preserved for appellate review. What this really boils down to is sort of the concept that making the appellate record begins and ends in the trial court. They talked about this. Appellate review is limited to the record as it existed before, at the time the trial court rendered its decision. A reviewing court cannot add matter to the record before it, which was not a part of the trial court's proceedings, and then decide the appeal on the basis of the new matter. I'm going to talk a little bit about avoiding some of the issues we see with error preservation in different circumstances. I'm going to run through some of these really quickly because some of them I'm sure you know about, and I'm going to focus on things that we see from time to time that you might not expect or that you might not be aware of. Make sure important conferences, sidebars, etc. occur on the record. Although everybody knows to do that, we still see a lot of cases in which the whole discussion of the objection was off the record and there was no summary when you got back on the record of what it was. You've got an issue about error preservation with regard to whatever that objection was. Make proper objections on the records to evidence jury instructions, jury interrogatories, and verdict forms to preserve error. Make proffers of excluded evidence, offer additional alternative jury instructions or interrogatories, and make sure that they are part of the record. Read them into the record, file your alternative proposed jury instructions. Those are ways you can get them into the record. Review jury verdict forms and raise any objections before the jury is dismissed. Request findings of fact or conclusions of law if appropriate. Make sure your exhibits are actually admitted into evidence. We see this issue more with hearings than we do with trials. I think that sometimes the informality of a hearing, something will be shown to a witness and discussed, but then the document never actually gets admitted as an exhibit at the hearing. So you just want to be careful with that. Oops, sorry, forgot to move. Make sure any electronic exhibits are in a format that can be readily reviewed by the appellate court. If you have some kind of really special software that you need to be able to review an electronic file, the court's not going to have that. So either try and convert it into some format when you're making your exhibit that can be readily reviewed by the court, or if there's some special software included as part of the exhibit. Sometimes we get things and the first thing that comes up, would you like to convert this file into another format? And no, I don't. I immediately call IT and say, what do I do? You know, if we're trying to look at something that's part of the record. So keeping something in a standard format is something to think about when you're doing your exhibits. If evidence is offered by video or audio recording, or if you're reading a transcript of testimony into the record, make sure those recording or transcripts are transcribed, either transcribed as part of the record or to the portions read or played are marked as exhibit and admitted into evidence. I have a sample here of a case where that's all we got. The recording was played. It wasn't admitted into evidence. We have no idea what the recording was. And a number of times we'll get transcript read. And the same thing, portions weren't transcribed. It wasn't admitted as an exhibit. And that evidence isn't part of the record. If only portions of a video or audio recording are shown during a trial or hearing, you may want to make certain that the exhibit that is admitted contains only that portion shown and not the video in its entirety or other video files. We see this a lot with surveillance videos or body camera footage. You'll get an exhibit that has like 10 files on it of different either different body camera videos or different views of something, and only like one of them is played at trial, and the whole exhibit gets admitted into evidence. Well, you really want to think if that's something you want to have happen. And in fact, I cited State versus Michael Jones. That's a case that's currently pending before the Ohio Supreme Court. In that case, there were 2 videos that were played before the trial court at a suppression hearing. And then an exhibit was admitted that it had like 8 other videos on it. And when the case went up to appeal with that entire exhibit, the appellate court actually relied on some information that was in some of the videos that weren't played before the trial court. And so one of the issues that's currently up before the Supreme Court is whether that's properly part of the record. I'm not going to opine on what the Ohio Supreme Court might do in that circumstance, but I did want to let you know that issues with regard to the record are something that are important. And if you are familiar with the Gwynn case that was recently reconsidered in the criminal context, the concurring in judgment only opinion that resulted in reconsideration was based on an issue with the record. So the record is important.
You want to be a little more specific?
Oh, okay. Yeah, I guess I'm sorry.
Because it is a critical issue.
Yeah, it is. In that case, the issue was the issue that resulted in sort of the reconsideration of the opinion was the fact that I believe it was Justice Fisher who said in concurring judgment only that he did not believe that the appellate court should have been looking, because the appellate court didn't have before it the pre-sentence investigation report that was used in sentencing, that the appellate court did not have the ability to actually review the sentence. And so that was the basis for his concurring in judgment only vote. And that resulted in the reconsideration. Whoops. Oh, no. Okay. I am not a techie person, as you can tell. And I might be oversimplifying that a little bit, but I did just want to point that out, that the issues with the record can really make a difference. Be careful about stipulations, particularly as they relate to the admissibility of exhibits. If you stipulate to the admissibility of something, you'll likely be stuck with that stipulation on appeal. Sometimes where we see this is where people stipulate not only to the authenticity of medical records, but the admissibility of medical records. And there's a lot of stuff in medical records. So just a thought there. Make sure you keep a copy of all exhibits in case they're later lost. There have been a number of instances where the court has directed the parties to try and supplement the record with a copy of a particular exhibit, and they're not able to do so because nobody kept a copy of them. So with regard to summary judgment, present proper summary judgment evidence below. You can't just attach anything to your summary judgment briefings and have it be considered as summary judgment evidence. 56C contains very strict limits on the types of materials a party can use to support or oppose a motion for summary judgment. Other types of documents may be introduced as evidentiary material only through incorporation by reference in a properly framed affidavit. Affidavits have to be by proper affiants with requisite knowledge in the proper form. And they have to be affidavits, not declarations, not unverified statements. We see that with some frequency. And make sure that your affidavits include all the attachments. We find a number of cases, particularly with regard to experts for some reason, where the attachments to the experts' affidavits were never attached below, and then they weren't considered by the trial court. They're not going to be considered on appeal. Don't forget to file your deposition transcripts with exhibits if applicable. If deposition testimony is referenced in summary judgment briefing. And this one is key. If your opponent's summary judgment evidence is not in the proper form, file a motion to strike or object at the trial court level. Where the opposing party fails to object to improperly introduced evidentiary materials, the trial court may in its discretion consider those materials in ruling on the summary judgment motion, and they may in turn be considered by the appellate court on appeal. We will see a lot of arguments sometimes where they'll say, well, you know, on appeal that this shouldn't have been considered because it wasn't in the proper form as required under 56 C and E. But the issue was forfeited because they didn't actually raise that issue with the trial court. If you've got a magistrate's decision, make sure you file timely specific objections to the magistrate's decision and provide the transcript of the hearing before the magistrate to the trial court if you want the trial court to be able to review the magistrate's factual findings and for those in turn to be reviewed by the appellate court. You can't file a transcript for the first time in the Court of Appeals and ask the appellate court to use it for appellate review when it was not provided to the trial court to review the magistrate's decision. Avoiding issues with docket and journal entries. If a docket or journal entry is entered that contains incomplete or incorrect information, promptly move to correct it and support your motion with evidence if appropriate. Even if the request is denied, at least then you have something in the record that you can point to on appeal regarding the challenged error. If there's nothing in the record to the contrary, the appellate court will likely have to assume that the trial court meant what it said or that matters occurred as stated in the journal, docket or journal entry. Oftentimes where we see this is where a continuance, they say the continuance was at the defendant's request. And there's nothing that, once you get to the appeal, there's nothing that you can say to rebut that. So the appellate court's likely going to have to say, okay, that's what the trial court said. Potential consequences if you fail to make a proper record below. You forfeit the issue or waive the issue for appellate consideration, or you're left with a plain error standard of review, which is a very strict standard of review. And if you are left with a plain error standard of review and you have a plain error argument, you want to make sure and actually make that argument, not just say the trial court committed plain error by X, Y, and Z. Reference the standard, show how you meet the standard. If you don't, otherwise you may not have properly presented that argument on appeal, and the trial court or the appellate court does not have to consider it. All right, another quiz. I've been talking a long time. This is another example of a case in an easement dispute. An expert real estate appraiser testified in support of the plaintiff's damages claim. When asked about comparable land sales, the expert didn't go into detail during his trial testimony regarding the issue, but stated that detailed information regarding the sales was in his report. The expert was questioned about 2 pages of this report, and the pages were shown to the jury during his testimony. However, the report was never offered as an exhibit. The report was nevertheless transmitted to the appellate court as part of that trial court file when the record was transmitted to the appellate court. So the questions I have are, is the report part of the appellate record? Could the report be considered in whole or in part by the appellate court when reviewing the trial court's decision? This example is based on a case that's cited below, LG Harris Family Limited Partnership. In this case, the court observed, as you might expect, that usually a reviewing court cannot consider an exhibit unless the record demonstrates that the exhibit was admitted into evidence in the lower court. It held, however, that although the pages themselves should have been offered and become part of the record, because the defendant did not object to the expert's reference to the content of the pages as part of the basis for the opinion, and the expert was cross-examined about the information, the appellate court would consider that content as part of the record on appeal. The reason I include this example is because personally, that's not a result I would have expected. With all that we're talking about importance with regard to what should be part of the appellate record and what shouldn't be part of the record. I just wanted to let you know that if you need them, there are some cases out there that you could cite to support an argument that material that was in fact considered below, this was in fact considered below, should be part of the appellate record, even if it was not formally admitted. Again, you've got that sort of abuse of discretion standard, so that's where that sort of comes into play. Not something I would rely on. As we're talking about best practices. You want to have all your ducks in a row if you can. You don't want to try to have to bring one back into the fold. All right, now we're up to that show me the money element. Citing to the record to support your appeal. This is sort of a basic thing. I'm going to go over it quickly, but it's not enough to have the information to support your assignments of error in the record. You have to show the appellate court where in the record it is. Appellate Rule 16A requires citation to the relevant portions of the record, and it tells you multiple times that you need to have references to the place in the record where the error occurred. 16D tells you how to do it. With regard to the potential consequences of failing to properly cite to the record, they are significant. Appellate Rule 12A2 says the court may disregard an assignment of error presented for review if the party raising it fails to identify where in the record the error is. In reviewing assignments of error, some panels will only look to those portions of the record to which they are specifically directed by the parties. And just as an aside, don't include facts that are not in the record in your appellate brief. At best, the appellate court will ignore them. At worst, it could lead to a loss of credibility. It could undermine their position, or somebody might try and move to strike it. And finally, as with all things, there are exceptions. An appellate court can consider information outside of the record to determine whether an assignment of error is moot. And judicial notice also applies to appeals. So there are circumstances in which an appellate court could take judicial notice of a fact, usually where you see it as sort of background information, dates that are taken from an online docket and then referenced as part of the appeal. That's all I have. We probably have a few minutes for questions, for not just for me, but for any members of the panel here. If you have them, let us know. We'd be happy to answer your questions now, or we'll also be available during the break if anybody has any questions.
When a civil matter is refiled under the savings statute, can they use the evidence that was filed in the first case as the second case, or what happens?
In terms of the appellate level or the trial court level, I mean, I think it's gonna
The appellate level.
I mean, if it's, unless it's part of, unless it was considered, this is my view, right? Not necessarily the court's view. And if you guys want to set what your thoughts are, my thought is you would likely need to get that specifically put in as part of the record in the refiled case. Either by stipulation, court order, that you would, as part of a best practices, for sure, you would want to make sure that that is in the refiled case and not simply rely upon it. One thing that we do have that comes up from time to time is if you have, a prior appeal that gets dismissed. What about the transcript that was filed in that prior appeal? Can you just assume that it'll be transferred over the new appeal? And I would say you don't want to assume that. Make sure that you file a motion to have that transcript in the prior appeal get applied to your new appeal. Otherwise you risk, as we're reviewing things and you see, oh, there's no transcript, you could risk getting an order and dismissing the appeal because you haven't filed the transcript. So I do know with regard to appeals, when you're looking at that, you do want to make sure, you know, dot your I's, cross your T's, and file that motion. You guys have any thoughts?
Yes, I would agree.
All right, thank you very much.